Hi, everyone. I'm told that it takes a moment for everyone's videos to kick in, so I'm just going to give it a moment. I can see the attendees list is slowly filling up, so I'll give that a sec to stabilize, and then I'll begin. Still going up. Golly, there's a lot of you. Okay, I think that has steadied. Hello, and thanks for joining us. For those of you who don't know me, I'm Ben Handy, and I'm joined today by Ted, my faithful and hopefully quiet dog. Ted and I are joined by James Hughes and Justin Valentine. They need no introduction, but I'm asked to have a go anyway. James joined Chambers in 2011 and was pupil to the great Glyn Edwards, who we all miss every day, and never more than when you need someone to do a decent introduction to a sleepy afternoon webinar. If you feel like you recognise James's handsome face from somewhere, then you might be remembering the inaugural 2016 Barrister Hotties list, in which he placed a creditable but contentious 5th. To quote from the awards website, James Hughes nearly didn't make the final cut because he looked so damn constipated in his profile pic. He since has a new Chambers picture, but hasn't featured in subsequent awards, which means you have to wonder if he doesn't look at his best slightly constipated. Justin joined us in 2016, having practiced in Liverpool for 15 years before that. He worked in 2 psychiatric hospitals before joining the bar, so he's got a wealth of clinical experience upon which to draw in his practice. If Glyn were here, I think he'd say that working in a psychiatric hospital is just the prep you need for coming to work at St. John's. Justin, I say this in no way because you're the judge in our mock CCMC today, but you are the finest barrister of your generation, and it was a travesty that you didn't feature on that 2016 Barrister Hotties list yourself. The 3 of us are going to do a short mock CCMC for you shortly. This is the penultimate episode of our autumn programme of webinars, which have covered a host of topics from contempt of court to accommodation claims, Erb's palsy and shoulder dysplasia to Animals Act claims. Yesterday, we had a mock hearing and a Highways Act claim, and today, our mock CCMC. You can find all of the videos for those sessions on our website whenever you need them, along with many others, and we hope you find them to be a useful resource. For today's hearing, a very short 18-page bundle has been sent out to you already, I'm told. But if you can't put your hands on that and you need another copy, you can send our Emily a very quick email on the address she has posted or is about to post in the chat. I can see she has, and she will send you another. The chat has been disabled at your end, so you can't post on there but yourselves, but you can see what we've posted. If you have any questions, you can post those using the Q&A function, which you'll see at the bottom right of the toolbar on the bottom of your screens. We'll certainly make time for any questions at the end of the session. I'm also asked to remind you that there'll be a survey that will pop up at the end of the seminar if you wouldn't mind completing that for us as well. Finally, a warning: to make sure you're awake, there is an element of audience participation today. At key points in the hearing, we're going to ask you to answer a question that will pop up on your screen, telling us what you would decide on certain key issues if you were the judge. I can't promise that His Honour Judge Valentine would agree with you today, but I don't know what he's going to do any more than you do, because yesterday James and I were trying to get him to tell us what he was going to decide and he wouldn't. He thinks watching us squirm is more realistic and more fun for you, and possibly for him too. And so with that, I think I've covered all the stuff I need to in introduction, and I'll hand over to our judge for the start of our hearing.
Thank you. Good afternoon, Mr. Hughes and Mr. Handy. Now, Mr. Hughes, I understand you're for the claimant, is that right?
Your Honour, yes, Mr. Handy for the defendant.
Can you tell me briefly what the issues are?
I hope Your Honour's had a chance to review the case summary. The court will have seen an accident at work which took place on the 2nd of May 2015. The claimant, then 35, his case is that he was caused to suffer a back injury while lifting a piece of metal on his own, which on his case weighed some 150 kilograms. The defendant accepts breach of duty by reason of there being no relevant risk assessment in place, but it says that, or it denies causation, and it says that in fact it only uses pieces of metal that weigh up to 50 kilograms.
Yeah, and he was told to get help.
Yes, so there's and its case is also that this accident wasn't reported, in addition to the claimant being required to ask for help and not being under a pressure of time, which is the claimant's case.
Yeah,
so
and medical causation is also disputed, isn't it? To the extent of injury, is that right?
It is. The claimant relies, the court will have seen, upon reports or report of Mr. Spine, the consultant spinal surgeon who examined him and reviewed the claimant's lengthy medical records, sent the claimant for an MRI, which revealed degenerative change in his spine, and the claimant seeks permission for an updated report from him.
Yes, I've seen that, and in the directions it includes disclosure of the claimant's full and up-to-date medical records. Have they not been sent to the defendant yet?
I'm told that the claimant has so far only disclosed one page.
Why is that, Mr. Hughes?
I'm not specifically instructed, Your Honour, about that. You will have seen from the case summary that there's a record by the GP 1 week after the accident, where it said that the claimant injured his back at work 5 days ago, lifting a heavy tray alone.
Well, I understand that, and that's a useful sort of contemporaneous support for the accident, but I'm just concerned that you seem to be opposing that they should instruct their own expert, that they should ask questions, but the medical records haven't actually been disclosed as yet. Is that right?
It is right, and it is right that we say that the defendant should first put questions.
All right.
To
but on the face of it, we'll come to that. But on the face of it, it's not a terribly attractive submission, is it?
Well, we'll seek to persuade Your Honour that if it's not a terribly attractive one, it is an attractive one. But I hear what Your Honour says insofar as it may have been a reasonable expectation by the defendant to have seen the claimant's full and complete medical records, but that's not the case at present.
No, well, we are where we are. All right, well, let's look at the directions. Now, you both agreed that it's allocated to the multi-track, and based on the schedule as drafted, that's obviously correct.
Yes.
Now, in terms of witnesses, you seem to be, well, one is uncontentious, isn't it, in the directions? Is that right, Mr. Handy?
That's right. We ask for a reasonably short timetable in terms of disclosure for the reason that you've already raised. Haven't had sight of the medical records yet.
All right.
Could I raise a point on witnesses? I know it's not set out as a matter in issue in the case summary, but I would like to raise a point if I may, and I wonder if actually you foreshadowed it with what you were about to say.
Yeah, well, go ahead, Mr. Handy. Yes.
You may have seen that the claimant seeks to rely on 7 witnesses, including himself, all of whom relate to quantum. Now, the claim as pleaded is for loss of earnings and care, and these witnesses are all friends and family, which presumably can only really give evidence as to care. Now, you will be aware that you have the power under Part 32 to limit both the number of witnesses, the length of witness statements, and so on, to that which is necessary. And the defendant has concerns that, frankly, 7 witnesses just isn't necessary for the claimant on those issues.
Well, on the face of it, Mr. Handy, I am sympathetic to that. I mean, I've noticed that in the schedule, it's claimed at 2 hours per week. So that's £10 a week. Mr. Hughes, is it right that the claimant is seeking to call 6 witnesses to support a £10 a week care claim, albeit one that he is claiming on the basis of the medical evidence as it currently stands for life?
Well, there is, in addition to that, the court will have seen a little bit less than £21,000 claimed, £21,000, I should say, claimed for future care and assistance.
Yeah,
the same amount, but the short answer is the nuts and bolts of the care claim the claimant would submit will be made up by those 6 additional witnesses. Yes.
Who are they?
Friends and family is all I can tell you. I can't tell you whether they're immediate nuclear family, but they're friends and family.
Why should I allow all 6 of those witnesses and potentially waste a lot of court time on something that's usually done by, as I'm sure you appreciate, Mr. Hughes, 1 or 2 witnesses?
Well, the court, I suspect what the defendant would be saying, if there was a small or no number of witnesses in respect of care, is that it's for the claimant to substantiate the detail in respect of that care claim. Now, whilst the court might think that that's a large number, in my respectful submission, it allows or potentially allows for a sufficient level of detail to help make out what is not an insignificant care claim. I understand the court might have initial concerns about such a large number. But
it's only significant, isn't it, because it's over his whole lifetime. It's actually £10 a week, isn't it?
I accept that.
Yeah.
But Your Honour has the request that my instructing solicitors have asked me to make in respect of the investigations that have already been carried out in respect of those friends and family. So 7 witnesses, we say.
And how long do you think those witness statements are going to be?
In addition to the claimant himself, the 6,
yes, I'm
the
ignoring
6 other
the claimant, obviously.
Yes.
These 6 other I'm interested in.
Well, not a great deal of time. I would, to the best I can, assist you on that. As I say, I don't know who they are yet, but I can't imagine that it's going to be 6 long statements. As you say, it's 2 hours a week, both in the future and in the past.
Mr. Handy, anything else from you on that issue?
I suggest limit the claimant to 3 witnesses, including himself, and maybe even limit the 2 additional witnesses to no more than 5 pages each or something like that.
All right, can we have the first poll, please?
I've been quite cheeky and answered that myself.
So did I.
Were you with me as well?
I can't tell you yet, can I?
Sorry, Mr. Hughes.
Do we have a result for that, Hannah?
A resounding no, it looks like. 85% no, 15%.
Well, Mr. Hughes, I'm afraid I'm with the participants here. It's very unusual to call 6 lay witnesses. I'm not going to go as far as Mr. Handy has suggested, but I'm going to limit it to 5 witnesses in total, namely the claimant and 4 others. It's a relatively small amount of care that's being claimed. It's only large in value because it runs for a considerable period of time, notwithstanding the fact that each witness probably won't take very long at trial. That I have to consider the logistics involved, especially in the COVID era and attaching all of these potentially via video conferencing. And I really don't think 6 witnesses as to quantum is excessive in my judgment. So I'm going to limit you, and you could record this please in the order, to 5 witnesses in total, namely the claimant and 4 others. All right, now what's the next issue of dispute, please, Mr. Hughes?
This is item number 7. I hope the court will have a version of the directions which has the contested directions in red ink and in square brackets.
Thank you, yes.
Yes, so the next issue for the court to adjudicate upon is whether the defendant had permission to obtain and rely upon its own consultant spinal surgeon, or as the claimant would have it, to first put questions, Part 35 questions to Mr. Spine. I just, if I may, I could correct something. I misspoke when I said that the claimant seeks permission for 2 reports. If I did say that, we've already served 2 reports to Mr. Spine and seek permission to obtain an updating report from him. So it would be 3 in total.
It's a substantive addendum, and you're looking for a further one. Is that right?
That's it. Thank you. So insofar as what we say about the issue, or the issue of whether the defendant should have its own permission, we say that the the case is put against, or the case put by the defendant is against the backdrop the claimant accepts of a pre-existing history of conditions or back problems. The court will have noted that on Mr. Spine's review of his medical records. But we say that in terms of cost saving for the purposes of potential issue narrowing, only if the defendant sees a causation problem in the answers it gets from Mr. Spine by way of Part 35, should the court then go on to allow for further permission for the defendant to have its own report.
You must know that these acceleration injuries are areas where medical experts often disagree. What are you suggesting to me, that if Mr. Spine in his responses said, no, there is no scope for disagreement with my opinion that this alleged accident caused all of his symptoms, then in fact the defendant wouldn't be allowed to rely on evidence? Or are you suggesting that if he said, yes, it could be an acceleration injury, then he would be allowed, or neither?
Well, it's probably neither of those, because I suspect that the trial judge might think that if Mr. Spine said that I don't accept that there's any basis for a range of opinion in an acceleration case, and the court might think that that's an unattractive analysis, and I would accept that. But what he does say in clear terms is that the claimant's degenerative change in his spine don't account for his ongoing symptoms, and he does attribute them to the lifting soft tissue injury which he sustained at work. So he clearly delineates between the two of those in my respectful submission, and it's against that backdrop that the defendant has any further grievance with his view as to causation that the court can take a further view. And I say that against the backdrop of a not insignificant, it's a fairly heavy claim of 382 and a bit less than £1,500 for past and future loss, with generals to go on top of that.
That's precisely one matter that concerns me, Mr. Hughes. Mr. Handy, anything from you?
There's several reasons why the defendant should be allowed their own expert. One you've mentioned, we haven't had the medical records yet. So we are where we are, but we haven't really been in a position to put questions to the expert. I suppose we could have relied on those records that he's detailed in his report, but of course that wouldn't quite be satisfactory. And frankly, the main reason is this: he's given a clear opinion. He's reviewed the medical records himself. He knows about pre-existing back problems. He knows that the MRI scan shows degenerative changes, and he's given his view. There's no point in us asking him whether he stands by that view, frankly. There is bound to be a range of opinion, and in a case of this value, we just seek a chance to investigate that ourselves.
Hannah, poll 2, please.
No, that's the wrong one, isn't it?
Not the right one. It's the, should the defendant have permission? Oh, sorry, poll 4, I do apologise. Should the defendant have permission to rely on their own spinal surgeon? Thank you. Well, yes, I'm in agreement with everybody there, 95% yes. In my judgment, the defendant should have permission. It is a notorious, as Mr. Handy says, area where there is a range of opinion. And I was struck by Mr. Hughes's frank response that whatever Mr. Spine said, whether he said, yes, there is a range of opinion, yes, or no, there wasn't a range of opinion, that in either circumstance, the claimant would still argue that the defendant shouldn't have permission. So I'm against you on that, Mr. Hughes. The defendant, of course, should have permission to rely on their own consultant spinal surgeon. It's a substantial case running into several £100,000, and it is acknowledged that this gentleman had previous back injuries. All right, can we look at the issue of putting questions to Mr. Spine? What do you say about that, Mr. Hughes?
Well, it's not one of the, just looking at the paragraph 5 of your directions, it's not one of those which is contested in any event
Well, I'm aware of that, but the issue I have to look at is proportionality and budgeting. I'm attempting to save costs here. So I just wondered, well, perhaps I should put the question then to Mr. Handy. Why do you seek and do you seek to ask questions of Mr. Spine? Bearing
I do.
I've just given you permission to rely on your own orthopedic expert.
Yes, I do seek permission. We haven't had the medical records yet. There might be relevant stuff within them. It's a reasonably low cost exercise to put questions to the claimant's expert, but if things arise that we'd like to clarify with him, then that's the point at which to do it, I would say. I do take the point that, frankly, we could build in a round of questions after the defendant serves its own expert evidence. Or I suppose these things could be mocked up in joint statements, but frankly, I would just say there's no point in waiting.
Right. Hannah, could I have poll 3, I think it is, should the defendant put questions to Mr. Spine? Yes, that's the one. All right. Mr. Hughes, I don't think questions should be put at this stage, and Mr. Handy, I don't think they should be either. Putting questions at this stage in the context of you getting your own orthopedic surgeon doesn't achieve anything, in my judgment. You're going to get your own orthopedic surgeon. I presume you're going to get that moderately soon. You've put it down here at 12 weeks. There will thereafter obviously be a joint statement from the spinal surgeons. If necessary, an agenda can be prepared and you can deal with the issues at that stage. I'm also concerned, of course, that the claimant is looking to rely on an updated report. So I really can't see the purpose of that. So putting questions to the reports that you've already got at this stage, and we can remove the cost of that from both of your budgets. So what about this issue of updated reports, Mr. Hughes, from Mr. Spine? Is that right?
Yes, the claimant's being sent for treatment on the NHS.
What's that treatment, please?
I can't tell you precisely what it is. I can tell you in terms that Mr. Spine says that the claimant's symptoms, his view is, may improve with that treatment. But he says, given the passage of time, it's unlikely. But nevertheless, the claimant's been asked to undergo that treatment, and you, as I say, you have the view of Mr. Spine. So that it's against that backdrop that we seek permission for one further updating.
When does the treatment finish?
I can't tell you that. Frankly, what I can tell you, the extent of which is that which you have in the case summary, but I don't know when it's due to finish.
All right. And when was the last examination of the claimant by Mr. Spine?
I can't, I'm afraid, tell you that about that either.
Do you know the answer to that, Mr. Handy?
I'm afraid it's not in the case summary. Shall we? It's likely to have been within the last 6 months, Your Honour.
All right. Can we have, therefore, the poll, should the defendant have permission to a further updated report from Mr. Spine? Which is question 2, I think. That's the one. All right, well, I'm going to refuse permission to an updated report from Mr. Spine. Mr. Handy tells me that the examination of the claimant was in the last 6 months. Mr. Hughes can't tell me what treatment that the claimant is going to get or when it might be finished. And I note that the directions here is it's an updating report from Mr. Spine. I've got to limit medical evidence, expert evidence, to that which is reasonably required. And I've heard nothing to persuade me that an updated report in the context of a previous report and in the context of treatment, which Mr. Hughes doesn't know what it is and when it's going to end, is in the slightest bit justified. So I think we're just going to have to go on the basis of the defendant getting their expert report and then a joint report between those two experts. And you say that that's going to be, when's your joint, no, sorry, I do beg your pardon. You're going to get your expert in 12 weeks. Is that right, Mr. Handy?
Yes, we've got an appointment lined up immediately.
You do. What's the identity of that expert, please?
I can't give you a name, I'm afraid. I have got instructions that an appointment has been lined up,
Right.
but I haven't got the name.
Provide that information within 2 weeks?
Oh, I could do it today, I'm sure.
All right.
I haven't got it to hand. Yeah.
Can you add that to the order, please? That the defendant do provide the name of their appointed expert within 2 weeks, and thereafter, obviously, a report from a consultant spinal surgeon within 12 weeks. Are you happy with that, Mr. Hughes?
Yes, I am.
All right. So then we've got a joint statement. Well, 14 weeks. That's a bit tight, isn't it? Should we push that back a bit?
Yes, wouldn't be a bad idea.
There's only 2 weeks from your experts. And if you do choose, I'm not going to order an agenda because I think it's too straightforward an issue for an agenda to be prepared. But of course, your respective instructing solicitors can set out the issues that they expect the experts to deal with in the joint reports. But I think 14 weeks is too short. Can we push that back to 16 weeks?
Yes.
Right.
Should we push the updated schedule of loss back another 2 weeks?
Everything else, push back by 2 weeks.
Okay.
All right. Now, what about attendance of experts at trial? What do you say about that, Mr. Hughes?
Well, we say that, if I can answer this by reference to the direction, paragraph 12 of the direction says that the defendant says a PTR not necessary, and given the way which the issues in respect of medical causation have already been framed, it would appear at least a possibility, if not a likelihood, that there's going to be a measure of disagreement between these two spinal surgeons, isn't there, in respect of both causation at all of the claimant's injury to or an injury to his back, and whether the ongoing causation of the claimant's back injury is attributable to the accident. Mr. Spine saying yes, it was a soft tissue injury against the backdrop of pre-existing symptoms. So we would respectfully submit, and we put a contingency in our budget for the expert to attend, that it's something that your honour can budget for now and should work into the directions that they will give such live evidence.
Have you budgeted it for it, Mr. Handy?
We haven't, and in fact, I note that the claimants have budgeted it as a contingency, which suggests they're not, forcefully suggesting that it's a likelihood that the experts are going to attend. I can see arguments both ways, to be honest.
Well, let's just put it like this, Mr. Handy. If your expert, as I presume you expect he will or she will, bearing in mind that you're for the defendant and you're instructing him, takes the view that this is an acceleration injury and say that he says it's a 3-year or a 5-year acceleration, that's going to reduce the value of the claim very significantly, isn't it?
It is. We don't know what the expert's going to say yet.
No.
Of course, and it wouldn't be beyond the wit of man to just make an application by either party if we need the experts to attend trial.
Well, all right. Well, what I'm going to, all right. Well, I think this is number 5, Hannah. Thank you. What I'm going to do, Mr. Hughes, Mr. Handy, is this. I'm not going to give permission at this stage for their attendance because I think it's important that the court sees these expert reports. It may be that in the joint report there is little disagreement between them. One of them might say 3 years acceleration, the other ones might say 5, for example, in which case I doubt it would be proportionate for them to attend trial, although it may be. But what I propose to do is this: I would like to budget for the attendance at this stage, and I would like the budgeting process to list as an assumption, and this is directed at you, Mr. Hughes, when you deal with the cost budgeting, to make it clear that the budgeting is done on the assumption that the expert will attend trial. Is that clear, Mr. Hughes?
In respect of the trial phase, or would Your Honour like to deal with that by way of the contingent phase that we've asked?
Well, it shouldn't be in the contingent phase at all. It should be in the trial phase. The contingent phase is not for matters like the expert attendance at trial. It should be in the trial phase, and we can move it over to the trial phase when we come to budgeting. And I think we'll just have to put something in your budget, Mr. Handy.
Yes, I'd be grateful. I'd seek parity with the claimants, but we can maybe cross that bridge when we get to it.
All right. Now the next issue got schedules, counter schedules, pre-trial checklist, PTR. PTR, Mr. Hughes, is that necessary?
We say it is. We say it is against the backdrop of the issues that we've already discussed. The defendant says not.
Well, why do you say it's necessary?
For the similar reasons that I look to impress upon you in respect of whether or not we should have live evidence from the experts at trial, namely whether or not this is an acceleration case or not, whether or not it's an ongoing soft tissue injury attributable to the accident or not. And given that Your Honour's said no permission for live evidence, but joint statement at the moment, and I agree with Mr. Handy, we can't speculate as to what the defendant's expert is going to say at the moment, but as I say, the claimant would submit that there is likely to be a measure of disagreement here, and that's more likely than there to be not a great measure of disagreement, if I can put it that way. So
what do you say, Mr. Handy?
I say that as long as we make a provision for dates to avoid to be filed, and as long as the parties bear in mind their power to make an application for live expert evidence when the need arises, if and when it arises, I think we can do away with the PTR. And I'd submit that's a really good and easy way of saving substantial cost.
All right. Poll 6, please, Hannah. Thank you. I think in the circumstances of this case, I think it would be useful to have a PTR. What I would like recorded in the order, Mr. Hughes, is that any application agreed, if possible, for the reliance on expert attendance at trial should be made 14 days before the PTR is listed. Is that clear?
Did you want to say 14 days?
14 days, yes.
Yeah.
I mean, I suspect that there won't be much disagreement between you as to the need for expert attendance at trial once you've got the joint report. But I think in the context of this case, I wouldn't normally order a PTR in this sort of case, but I think I would like to bring it back before me. And if you could reserve this case for case management before me, Mr. Hughes, I think I'd like to shake the tree somewhat at the PTR stage and see exactly how things are lying at that point. This is a claim which could be compromised, I suspect. I'm certainly not going to order a pre-trial settlement hearing. We don't do that on this circuit, but I do think it would be useful at that stage to take stock of exactly where we are. And that's why unusually I am going to order a PTR in this case. Otherwise I wouldn't have done.
With an eye on costs, Your Honour, are you requiring the parties to make a formal application? If they agree, for example, that experts should attend, can they just file draft directions?
No, I would like a formal application because I'm not giving permission at this stage, and I want to see the reasons set out. But clearly, if it is agreed, it can be a relatively short application.
Very well.
All right. Trial length, Mr. Hughes?
We say 4 days, the defendant says 3. Given the direction, sorry.
How do you break those days down, roughly?
Well, one matter that Your Honour hasn't yet adjudicated upon is the defendant's request to call 6 witnesses relating to working practices, how the accident happened, how the accident was reported to them, I'm sorry, and the claimant's previous back problems. All questions of fact, it says. If you allow those 6 witnesses, there will be 11 witnesses of fact in total. 2 consultant spinal surgeons to give evidence against a claim, or in the context of a claim pleaded at a bit less than £400,000. So at least a day and a half, the claimant would submit dealing with factual witnesses, and then, but that's probably more likely to be 2 days, and then another day dealing with medical evidence and judgment, which takes us into the after day 3 into 4 days.
Right, Mr. Handy. First of all, is that right that you're relying on 6 witnesses as to liability?
We are. I haven't addressed you on it because it hasn't been raised before.
No.
But you know, I'm conscious that I need to stand my ground on this if I think it's right. I do say it's right. I'm conscious that there's a difference in principle really between the reason that the claimant was going to call its witnesses.
I agree there's a difference in principle, but the question I just asked you is, do you need all of those witnesses?
Well, we do, but you bear in mind that on liability here, we have a question of whether the claimant was in fact given what he needed by way of information and training to protect himself, whether or not he reported the accident until a month later, and this issue that his colleagues have said that they saw him struggling with his back visibly in the weeks before the alleged accident. Now, each of those is contentious. And it's not good enough to say, well, the defendant could call 1 or 2 witnesses to give that evidence. They could, but the weight of evidence is just as important here. The weight of evidence on a factual issue like that. Mr.
Handy, you don't need to trouble me any further. Mr. Hughes, you didn't raise this issue about witnesses when we were discussing witness statements. Mr. Handy is right that there is entirely a different point of principle here if they're liability witnesses. There's no ownership in a witness, of course, Mr. Hughes. If there are workmates who can support the claimant, then well, you can seek a witness statement from him, and obviously subject to court order, you can rely on them. I'm certainly not going to limit those witnesses at this stage. Mr. Handy, what do you say about the trial length?
The defendant says that this can be done in 3 days. Again, to be honest with you, I can see arguments both ways. It is easier to lose a day from a court list than it is to gain a day. I'm conscious of those things, but nevertheless, I do say 3 days isn't particularly optimistic. I think that does build in enough of a contingency to properly deal with this.
All right. Hannah, could we have poll 7, please? Thank you. I think I'm going to order this to be listed for 4 days. I think Mr. Handy's right that it's much easier to lose a day. But again, in the assumptions, Mr. Hughes, if you could specifically say that this is on the assumption that the experts attend trial. I think if they don't attend trial, it can easily be reduced to 3 days. But I think if they do need to attend trial, then 4 days will be required. All right.
And presumably the experts only needed to attend 1 day of trial. They don't need to be there for more than that.
The experts only need to attend 1 day at trial, yes. Is that right, Mr. Hughes? Do they need to hear the witnesses from the defendant saying that he complained about his back or not?
It would. Well, the experts would certainly need to hear about the time from which the claimant was complaining with an injury to his back, which he attributed to his accident at work, and also the mechanism of injury. So yes, to the extent that those factual witnesses spoke to those issues, the claimant would submit that they would need to hear that evidence to give a view on causation or not to the accident.
Do you agree, Mr. Handy?
No. I mean, it's with an eye on proportionality. It's expensive to get experts in the room. They can frankly be told if anything particularly material comes out of the mouths of a witness that they don't already know.
Well, I'm reluctant to have the witnesses, the expert witnesses, come for 2 days, but I think that it's right that, in the interest of justice, that they would have to hear some of that evidence. Now, they won't necessarily have to hear, obviously, evidence as to quantum precisely, nor will they have to hear evidence about the risk assessments and training that the claimant did or didn't receive. But I think it's important that they are apprised of some of the evidence in relation to the previous complaints, because that is relevant, it seems to me, as to their opinion. So I think they'll need to come for 2 days, and we'll have to budget accordingly. But again, that's going to be listed in the assumptions, Mr. Hughes, if you would.
Thank you.
All right. Is that everything on the directions?
Yes.
Yes, it is.
Okay, let's look at the claimant's budget. And we'll see if we can rattle through this, gentlemen, if we can. Do I have a President R as well?
You'll find that on page 11.
Thank you. Okay, so pre-action costs, issue statement of case. Now that is opposed, Mr. Hughes. You asked for 1152, is that right?
That's right, and the defendant says that's disproportionate and allows about half that, £576.
All right, it's not a huge amount, is it, Mr. Handy, for updating a substantial schedule?
It's not so much that that's a disproportionate amount, but it's the issue we take is that £3,500 has already been spent to put together something that, yes, I mean, it's a substantial schedule in terms of pounds, shillings and pence.
Mr. Handy, £2,500 of that was a court fee.
That's a fair point. That's a fair point, Your Honour.
All right. I'm not going to tinker around the edges with these sums. I'm leaving that as it is. CMC, well, the practice direction says it's in the past, isn't it? So could you, in the revised front page of your President's H, please move that into the incurred? And that goes for both of you.
Yes.
Next stage, disclosure. So you're asking Mr. Hughes for £2,215 and you're offering 1,060. Is that right, Mr. Handy?
You have it, Your Honour. 12.5 hours is claimed, 4.5 hours has already been incurred. And in terms of the claimant's disclosure, we're talking about medical records, really. It's not that much.
What do you say about that, Mr. Hughes?
Well, that's still going to take quite some time, is what we would say, and also to consider the list of documents disclosed by the defendant is the other assumption on which we draw this phase of the budget. So the phase as is budgeted for is what we ask for.
Right. I think I'm going to allow 1,500 there. I think you should have done most of the work. There may be more disclosure needs to be looked at, but I think 12.5 hours is too long, or rather 2,215 is too long. So I'm going to allow 1,500 and the disbursement of £100 going forwards.
Thank you.
Witness statements. Now you seek
big difference here, Your Honour, yeah.
And 1,000 for counsel. What do you say, Mr. Handy?
We say this is disproportionate in the truest sense. It's 50 hours of time. 5 witnesses is what you've allowed. Actually, my learned friend makes the concession, and it's obviously right, that where they're giving evidence about care, not going to be lengthy, these statements. I can understand why the claimants might need to be, but overall we say 20 hours and we'd allow £500 for counsel's fee for what should presumably be a reasonably short con.
All right, what do you say, Mr. Hughes?
Well, that ignores the work that needs to be done in respect of the defendant's 6 witnesses, 11 in total. And we say that against that backdrop and given the issues in the case, the value of the claim, it's also reasonably proportionate to allow for £1,000 to be spent on input from counsel as to the way to prepare the claimant's witness statements in particular, but also observations in respect of the evidence on which the defendant relies. So when you tot all of that up, the court might first have raised an eyebrow to the 50 hours claimed, but 11 witnesses, it's a lot of work to be done.
All right, well, I'm going to allow 6,000. I think you make a fair point in relation to examining and reviewing the defendant's witness statements. And I'm going to allow counsel's fee as claim because I think it's very useful to have counsel's input on witness evidence, particularly when it comes to reviewing the liability aspects. I haven't really allowed there, Mr. Handy, a lot for the care. But I think the fact that there is the claimant's statement and then 6 witnesses from the defendant, all on liability, all of which need to be reviewed, I think 6,000 is appropriate and proportionate in the context.
Yes, very well.
All right, experts. Now we've got, well, the Part 35 responses are coming out, aren't they?
Yes.
And the estimated report is going to come out, isn't it? Because I haven't allowed a further report.
Yes.
So the only additional expert evidence is £2,000, isn't it?
For disbursements, yes.
For disbursements, and then there's also a counsel's fee of £1,250. Is that right, Mr. Hughes?
Yes, it's for an advice. And I'm just checking whether it's a written advice or the form of the advice. Yes, it is. It's a written advice on quantum. I was right, or my instinct was right.
Why is that in the expert report phase?
Presumably because counsel, once seized of the joint report, will be able to give a better informed view of quantum.
Well, I would have allowed a conference with counsel, but you haven't claimed a disbursement for a conference with the spinal surgeon. I'll be sympathetic if you try to put that back as an advice in quantum in the appropriate phase, namely the ADR phase.
ADR, yes.
Yeah, but I'm not allowed, as I say, if you'd sought a conference with your spinal surgeon, and I'm very surprised you haven't, then I would have allowed it, but you haven't budgeted for it, so that's going to come out. So that just leaves the profit costs of £4,312. Any observations on that, Mr. Handy?
Yes, Your Honour. I mean, we suggested 10 hours when that was on the basis that there would be a further report from the spinal surgeon. There would be some Part 35 responses. You know, frankly, arranging an agenda and some back and forth with the experts in terms of joint statements, 8 hours.
All right, I'm going to allow 2.5 for the profit cost, the time costs.
£2,500.
£2,500. All right. Can I leave you to do the maths?
Yes, of course.
Yes.
Now we get to the Ptr stage. Any observations on that, Mr. Handy, bearing in mind that I have ordered a Ptr?
You have. I still say that the 5 hours claimed is a little high. A pre-trial checklist needs to be prepared, possibly an application relating to the experts, but really should be no more than 3 hours.
Well, I would customarily allow 3 hours for completing a form, but I have ordered a hearing. There will have to be instructions to counsel and presumably discussions around the expert evidence. I'm going to leave that as it is. All right, trial preparation. What's the £2,000 for, Mr. Hughes?
Say that again, Your Honour. I'm just.
What's the £2,000 conference?
Yes, with counsel at chambers, it says, and with instructing solicitors and the claimant, but it's not that the experts aren't listed there. So it's an in-person conference with instructing solicitor and the claimant in person.
What do you say, Mr. Handy?
We've already allowed for a conference with counsel at service of witness statements. I say there's not much more to be gained at that point in terms of trial prep. I do see why an advice on quantum might be required, but that can be budgeted at ADR rather than here. I just say it's not really something that's likely to take the claimant too much further. Certainly not £2,000 worth.
All right, I'm going to allow 1,500. The previous conference it wasn't a conference, it was an advice on the witness evidence. I think it's wholly appropriate that counsel has a conference with the claimant before trial, but at £1,500. What about the profit costs, Mr. Handy, 6,200?
Oh, again, far too high. It's right that the claimant has at least recognised that some of the work will be done by a grade D rather than a grade B, but the balance is still out of whack, we say. Right. What we propose is 15 hours at grade B. How the claimant then splits that is, of course, a matter for them.
Well, I'm interested in sums, of course, not hours. £4,000. And I would also like, when this budget is redrawn, you will both know, I'm sure, that the trial fee for counsel should appear in the trial preparation phase.
Yes, that's quite right.
That needs to be shifted over, and the relevant deduction made on the trial phase. Now, looking at the trial phase, you've got brief fee 5,000, so the trial preparation needs to go up, assuming I allow the 5,000. And then that's 9,000, 3,000 for each day. Is that right, Mr. Hughes?
Correct. 3 lots of £3,000 refresher fees.
What do you say about that, Mr. Handy?
You'll see from our precedent H, we said £12,000 for counsel for a 4-day trial. So we're slightly lower.
All right. I think 12,000 is ample. If you're allowing 5,000, then that would leave 7. Well, that doesn't. The maths doesn't work very well there. Can I leave you to sort out how to split it?
Yes.
But we've ordered a 4-day trial. Brief fee needs to go in the trial preparation phase. And what about the £6,912?
Sorry, the 6,912.
Yes, that's the profit costs, estimated cost for the trial phase.
Oh, it's the issue here is attendance. I mean, the claimant has budgeted on the basis that a grade B fee earner will be sitting behind counsel throughout this trial. We just say it isn't necessary. Certainly some time needs to be allowed, perhaps on day 1 for an in-person attendance, perhaps on the final day for an in-person attendance. Other than that, some time on the end of the phone should be sufficient. All
right, what, Mr. Hughes?
Well, defendants very often say that. It's important in a 4-day trial that the claimant respectfully submit that the fee earner is there to take a careful note in addition to counsel throughout the duration of this trial. So 36 hours we submit is well within the reasonable proportional amount that the court could allow for this phase.
I'm going to allow that. As you both as gentlemen may know, we've all had to do a lot of remote trials, and it's quite customary for the solicitors to attend for the duration of the trial remotely. And I think it's wholly appropriate and it assists litigation. So I'm going to allow that. I may be out of kilter with some of my fellow judges, but call me a bit old-fashioned, I'm going to allow that. Now we're going to need to put in there, aren't we, the contingent phase, is that right?
Expert attendance, you're quite right.
Yes, so you put that at 4 days at 2,500, so that's going to need to go in there, isn't it, at 5,000 for 2 days?
We would suggest £1,500 is more than enough for the expert per day.
Well, what do you say about that, Mr. Hughes?
Well, it's a bit of horse trading there, isn't it? I'm not sure where that figure comes from, but you'd be tinkering for the sake of tinkering, we say.
No, I'm going to allow it at 2,500 for each day. What, Mr. Hughes, are the 12 hours, however, on your contingent phase?
I suspect, but this is not much more than an educated guess, it's for work done by the file handler or negotiations with discussions with the expert.
All right, I'm not going to allow that. I've been generous with the attendance at trial of the solicitor. So I'm happy, and I'm happy for the 5,000 for the expert attendance at trial to be carried over, but no additional profit costs.
And with that, the contingency disappears.
The contingency obviously disappears. Yes.
Yes.
Fine.
ADR.
Shall I address you on this first?
Well,
Well,
Mr. Handy, you go first. You're critiquing
Thank
it,
you.
aren't you, so to speak?
Yes, I mean, the offer we make is based on the fact that we say there will be no JSM. We say 5 hours grade B and £500 council's advice fee, although I take it you were prepared to allow more than that for council's advice. But
Yes.
this is a case that is, I take the point that it is reasonably high value. It is not a case where that value comes from any undue complexity. It's a lifetime. It's a lifetime. That's the reason why the figures bounce up.
What do you say, Mr. Hughes?
Well,
JSM or no JSM?
It's perilous indeed for a defendant to categorically say at this stage there will be no JSM, and the thinking appears to be the reason that the claim is so high is that there's a future loss of earnings to age 65, but there's no other complexity which doesn't or provides for a joint settlement meeting. We say that's not it's a flawed analysis, and given that the defendant puts in issue the question of whether there was an accident that happened or not and causation of injury, there are other risks which can be pulled into the mix.
That's a fair point, isn't it, Mr. Handy? It's not just horse trading over quantum, is it? There are issues of causation here in relation to liability. I'm going to allow it, but I want it specifically listed in the assumptions, that it be on the assumption that there is a JSM. And that means, Mr. Handy, if there isn't a JSM, those costs are not recoverable in the ADR phase.
Yes, I hear that. Thank you.
All right.
Could I just ask then, in terms of those things that you have budgeted for in the claimant's budget, for example, PTR, for example, JSM, could I just seek parity in terms of numbers in the defendant's budget?
You can. Now, we don't have time now because it's 4 minutes to 2 to go through it, but I would have allowed parity and we would have done the best we could.
Thank you. There were not many issues on the defendant's budget, certainly not compared to the claimant's.
But I would have altered it for parity, notwithstanding the fact that most of it had been agreed, because otherwise that would be a nonsense.
Mm.
So, for example, 4 days rather than 3 and so forth.
Okay.
That's it.
Your Honour, thank you, yes.
Thank you both.
Breaking the fourth wall then, for those of you, 91 of you who are still with us, any questions? I've got a couple of comments from Mark on the Q&A.
Mark thinks I've been hung out to dry by inadequate instructions. I agree, Mark. Thank you for that.
I should say that I drafted those instructions. I feel
I agree, but I think the thing is, counsel for the claimant needs to be a little bit more creative on the hoof. You
don't lie enough, James.
You should have made it up. Ben made it up, and he said it was in the 6 months. If you said he'd been examined 2 years ago, then I would have allowed you your updated report.
Yeah, it's worth saying, pausing there, we sort of rattled through the budgeting part of that because, frankly, it wouldn't be that fun for you to sit there watching us do the sums. But in reality, most of the time in a CCMC, you would sit there and you would at least have an order that the council go outside and do the numbers and agree them before you leave the building. I don't know about you two, but I speak from experience where if you leave the building before things are agreed, you end up having hundreds of emails.
I try to do it as
most important thing. Important thing.
Yeah, and get everything agreed. You don't want to be arguing about a stray £250 when you're back home. Yeah,
but interestingly, I mean, I've had differences of approach in terms of parity. You know, where we've got defendant's budget, which is largely agreed, and I ask you, will you allow us to add a bit here and there? Generally, judges say yes, but I've had the odd judge be really difficult about that and say no. I actually don't know what the legal answer to that is, whether they should or shouldn't. But frankly, in terms of just being practical and trying to get things done, it's got to be the right way, hasn't it?
Yeah, it's the pragmatic thing to do, and probably the logical thing.
Sure.
I'm not sure what the legal answer is. Yeah, I agree.
Are there no other questions?
Nothing has been asked because clearly it was so good that there is nothing to ask.
Yeah.
Thanks, Justin, for being our guest judge today.
Thank you.
Yeah, thank you, Justin.
Thanks, James, for letting me hang you out to dry with your instructions.
My pleasure. Thank you.
Thanks, Emily and Hannah, for sitting there in the background and making all of this work, and also to the to all of you who attended and watched. Thanks again. And can I just finish by saying, Rodri Jones is doing the final seminar. I think it's next week, but please go on the website and have a quick look, and I'd urge you to attend that as well. Thanks a lot. Take care. Oh, and fill in the feedback form. I'm right. That's right, Emily. Thanks for the nudge. Thank you, everyone.
Thank you.
Bye.